Hello everyone, this is your host Urvashi Chauhan. Welcome back to another episode of Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. In a significant development, the Supreme Court today expressed its dismay in a case where an accused lodged in Manipur Central Jail could not be taken out for medical examination because he belonged to the Kuki community. The accused appeared to be suffering from piles, tuberculosis and severe back pain, which he had reported to the jail authorities. In November 2023, a medical officer examined him and noted tenderness in his lower spine, recommending an X-ray. However, Manipur Central Jail did not have the necessary facilities for the X-ray. When the matter was brought to the High Court, it expressed concerns about the accused's safety if taken out of jail due to him belonging to the Kuki community and the potential law and order issues. The bench comprising Justices J.B. Pardewala and Ujjal Bhuyan today directed the state to immediately make necessary arrangements to take the accused to Guwahati Medical College in Assam and get him examined there. It has ordered the concerned officials to obtain detailed medical reports in this regard and place the same before the court by 15th July. It was also made clear in the order that all the expenses were to be borne by the state. The top court also recorded in its order that it could have made observations regarding the approach of the state as well as the High Court, but presently it was refraining from doing so. Coming to the Hathras Stampede incident now. The tragic event organized by a self-styled godman named Bhole Baba, also known as Narayan Sarkar Hari, resulted in a devastating loss of over 120 lives. The incident occurred during a religious gathering where thousands had gathered to participate. As the crowd surged forward, chaos ensued, leading to a stampede that left more than 25 people injured in addition to the fatalities. The aftermath of this disaster has raised serious questions about crowd management and safety protocols during large-scale gatherings. Two different public interest litigations have been filed in this case, one in the Supreme Court and the other in the Allahabad High Court. The PIL, moved by Vishal Tiwari in the Supreme Court, seeks to appoint a 5-member expert committee under the supervision of a retired Supreme Court judge for an inquiry. It also calls for initiating legal action against the authorities and officials for their negligent conduct. To ensure that such incidents are avoided in the future, the petitioner has prayed for a direction against state governments to issue guidelines for cases where there is a large number of public gathering. The another PIL has been filed by Advocate Gaurav Dwivedi in Allahabad High Court, which seeks a CBI inquiry and suspension of the responsible officers for their negligent acts. It claims that the district authorities were totally responsible for the negligent act due to which the stampede occurred, and that this type of inappropriate law and order situation in the state would lead to people losing faith in the government. Alternatively, the PIL plea seeks independent judicial inquiry into the present matter. The petitioner has also sought compensation for the victims. Next, an update on the plea filed in the Madras High Court seeking to declare Hindi names of the new criminal laws as ultra vires the Constitution and the Official Language Act. The petition points out that the Hindi names of the new laws violate fundamental right to practice any profession of the non-Hindi speaking people. The bench of Acting Chief Justice R. Madhavan and Justice Mohammad Shafiq heard the matter today. The Union government today informed the court that there was nothing unconstitutional in the Hindi names of the 3 new criminal laws. Additional Solicitor General A.R.L. Sundaresan informed the bench that the Parliament, in its own wisdom, had named the new laws, and unless these were shown to be inherently illegal or unconstitutional, they cannot be interfered with. The counsel for the petitioner said that as per Article 348 of the Constitution, all authoritative text was to be in English. He pointed out that names of the new laws were also an authoritative text which was to be quoted by lawyers often. To this, the ASG argued that names of the new laws were also in English as English letters were used. He added that with the passage of time, the public as well as the lawyers would get accustomed to the new names. He further submitted that names of the new laws did not affect fundamental rights of any persons warranting any interference by the court. The court, upon noting that a similar petition was pending in the Kerala High Court, decided to wait for the proceedings before the Kerala High Court and therefore adjourned this case. The Supreme Court bench comprising Justices J.B. Pardiwala and Ujjal Bhuya today granted bail to an accused who was in jail for 4 years, accused under the UAPA. The bench was hearing an appeal against the Bombay High Court order that declined to release the appellant on bail. According to the allegations, in February 2020, the Mumbai police apprehended the appellant based on secret information. Following the operation, counterfeit currency notes allegedly from Pakistan were recovered. At first, the counsels for the National Investigating Agency and the state today prayed for time. However, considering the prolonged incarceration of the accused, the court declined to adjourn the matter. The court sharply rebuked the NIA for delaying the trial and asked to not make a mockery of justice. The top court, apart from considering prolonged incarceration, also noted that the two co-accused had been released on bail. It ordered that however serious the crime may be, the accused has a right to a speedy trial under Article 21 of the Constitution. In view of this, the court granted him bail and a precondition asked him not to leave Bombay and be present before NIA's Bombay office in 15 days. In another update, Delhi Chief Minister Arvind Kejriwal today moved the Delhi High Court seeking bail in CBI case related to the alleged liquor policy scam. You are aware that Kejriwal is in judicial custody in the corruption and money laundering cases related to this alleged scam. Notably, Kejriwal has directly approached the High Court for seeking bail without approaching the trial court. The matter was mentioned today by Advocate Rajat Bhardwaj before a division bench headed by Acting Chief Justice Manmohan. He argued that Kejriwal had been taken into illegal custody by CBI without compliance of Section 41 of the CRPC. The bench has allowed urgent listing and the same will be taken up on 5th July. Stay tuned. The Supreme Court has reiterated the settled legal position that an accused's right to a speedy trial is fundamental and closely connected to right to life and personal liberty. The court deprecated the order of the High Court, which overlooked the said principle and released the petitioner on bail for merely 2 months when the trial would take a long time to conclude. The vacation bench of Justices J.B. Pardiwala and Ujjal Bhuya was hearing a challenge to a bail order granted by the Odisha High Court. As per the impugned order, the petitioner was released on bail for only 2 months despite noting that he had been in custody since May 2022. The charges imposed on the petitioner were for the offence of contravention in relation to cannabis under the NDPS Act. Noting that the accused's right to speedy trial, the court granted bail to the petitioner while observing that the High Court erred in limiting the petitioner's bail period to only 2 months. And lastly, a Pune court has granted bail to the father and grandfather of the minor accused in the Pune Porsche car accident case for allegedly pressurizing their driver to take the blame for the accident and wrongfully confining him in their house. The father, a prominent builder in Pune, is booked in 3 cases related to the accident. 1 under the Motor Vehicles Act and 2 separate cases under the IPC for wrongfully confining the driver and manipulating the minor's blood sample on the night of the accident. The grandfather is booked under a single case for alleged wrongful confinement of the driver. The Bombay High Court last week ordered release of the minor accused from the observation home, criticizing the haphazard manner in which the prosecution and law enforcement agencies handled the situation, influenced by public outcry. This is the incident where the 17-year-old son of a prominent Pune builder, allegedly driving a Porsche Taycan under the influence of alcohol, lost control and hit a motorcycle, resulting in 2 fatalities. The car lacked number plates and the group had consumed alcohol before the accident. Initially granted bail by the Juvenile Justice Board on the same day, the minor was later remanded to an observation home till 5th June. The board had also rejected the plea to try him as an adult. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.